waiting us. We had a few technical problems, but we are now with you. And we have today is the sixth podcast of the Ukrainian Global Law Talks. And we again turn to the topic of the special tribunal for the crime of aggression of Russia in its war in Ukraine. And we will be discussing how the special tribunal has been or will be created and what we need to, what we expect. And we are organizing this as the Ukrainian Bar Association. We focus this series on various legal developments and initiatives shaping the legal agenda, not only in Ukraine, but also internationally. As you remember, those of us who listened to the previous topics, we touched upon the issue of international law and the special tribunal several times with our previous speakers, namely with Mark Ellis from the International Bar Association and with David Crane from the Global Accountability Network. But we also took some time to wait for this podcast to happen, and that's why we didn't have one in May, because we were waiting for important news that have happened in the middle of May, and we'll talk more about that today. So I'm really pleased to welcome two speakers today. So this is also a special podcast, not a regular one on when we do it one-on-one. So we have Anton Koronevich with us, who is a director of the Department of International Law at the Ministry of Foreign Affairs of Ukraine, who is an ambassador at large and Ukraine's agent at the International Court of Justice. And we have also, and we're very pleased and honored to have York Polyakevich with us, a director of legal advice and public international law at the Council of Europe. York is in the process of switching on his camera, so we'll start, but I very much look forward to York's input in our discussion. And also, breaking the tradition, we are also having this event today with two hosts. I'm very pleased to introduce my co-host today, Inna Lenyova, who is the director of the Human Rights Institute of the Ukrainian Bar Association. And Inna has been involved a lot in various initiatives, not only relating to human rights, but also to the to issues of international law, and in particular, accountability of Russia for the crime of aggression and numerous other crimes. So, Inna, to you.
Thank you, Mykola. I would also like to join you in welcoming our distinguished speakers and expressing our gratitude for your time and knowledge that you're willing to share with us. We know and remember that in March this year, it was finally announced that the statutory documents for the establishment of the special tribunal for the crime of aggression were finalized and received political endorsement at the level of ministries of foreign affairs. And this is an amazing result of work of the core groups, but also a number of international experts, civil society, and various advocates of accountability and allies of Ukraine. Today, we would like not to repeat the previous discussions that we had dedicated to the tribunal, but we would rather like to look behind the scenes and see what is happening with the process of establishment of the tribunal now. What are the legal, financial, or political challenges that we know of? And we hope that our guests would be able to share some elements to show us how things work behind the scenes with the tribunal. We have a number of questions that we would like to ask you, and I would like to start with the first one, and questions are addressed to both speakers, so please jump in if you would like to contribute. I would like to start with the question of whether the position of the Council of Europe member states is unanimous on the establishment of the tribunal. Are there any states who already agreed to join the enlarged partial agreement, and other states that declined and disagree with the establishment of the tribunal, because we read in the news now and here and there that certain states made their decisions. So, colleagues, if you would share the behind the scenes of the process, I would be very grateful.
Well, good afternoon, dear colleagues from Kiev. It's really a great honor and pleasure to participate in today's discussion and to do this together with Jörg, our good friend and partner in crime, if I may say so. Since we really, I believe, did a good job together in finalizing the process for the drafting of the statutory documents for the special tribunal. So first of all, of course, many thanks to the Ukrainian Bar Association and all the Ukrainian legal community for supporting the idea of establishing the special tribunal, because it's really very important, especially when we talk and when we cooperate with our international partners, that the issue of the establishment of the tribunal is really of great importance for Ukraine, for Ukrainian people, for Ukrainian legal community, for Ukrainian society, so that this is not only the view of the government, but that this view is really supported by our legal community and society as a whole. So really many thanks for UBA for all the efforts, all the events and everything what you did and what you will do, I'm sure, in order to support the endeavor. I think that the question is really more of a political nature than the legal one. And of course, we may not be sure now about any legal and political constraints or positions from particular governments of the Council of Europe member states. But what is important, I think, to clarify here is that for this process, we do not need unanimity. So for this process to be for the decisions of the Committee of Ministers of the Council of Europe, and in the Council of Europe, Committee of Ministers is the highest decision-making body, executive body. For this decision, which will hopefully authorize the Secretary General to enter into agreement with Ukraine on the establishment of the special tribunal, we will need 2/3 majority of the member states. So since we have 46 member states of the Council of Europe, so it's like 33 member states. So we right now currently, of course, understand that there will be states which will not support the endeavor. Maybe somebody will vote against. Maybe somebody would abstain. But we really hope and work hard in order to secure this 2/3 majority for the member states to secure the right and to instruct the Secretary General to enter into bilateral agreement with Ukraine on the establishment of the special tribunal. In relation to the enlarged partial agreement, I also think that we are not there yet to talk precisely and concisely who is going to be there and who doesn't want to be there. But we are again in constant touch with many governments, with all the legal advisors who participate in the core group. And we know that many European states are really seriously considering joining the EPA. Many non-European states are also considering joining EPA either as members or associate members. So I think that it all depends on the process in Strasbourg, which maybe Jörg would give also his view on from the town. But I think that all in all, we are in good shape. And the process is going on, and I don't see any political or legal impediments or hurdles to the process itself. Thank you.
Yeah, thank you. I think now you can see and hear me. We are not in the
Yes.
it's just a PC link, so you don't see my colleagues, but I'm here together with Konstanze Schimmel and Irene Suminen, who may come in at some point, because actually I may have to go to the Committee of Ministers where the point is being debated today, the tribunal. But first of all, let me also express my gratitude for this event. I'm very happy to participate. I've been to Ukraine several times, in Kiev and also Lviv for the historic event, the ministerial conference. And it's always a pleasure to come to your country. And we are, as I said, we really worked very well together with Anton and his team. And we achieved something incredible. I think at the beginning of the process, I never thought that we would come that far because in the beginning it looked like a really difficult task to bring together so many countries with very different attitudes and approaches to the issue, and to combine them on this common endeavor. And now to your question, as I said, the issue is how the Council of Europe will now deal with the legal instruments that have been transmitted by Ukraine at the ministerial session in Luxembourg to the Council of Europe, how they will be processed, so to speak, here. And I think the vibes, as one says nowadays, are very good in the room. There is strong support, and countries want to go even faster than we imagined, which is good. And precisely to your questions, it is obvious that I think it's not a secret that not all member states unanimously support this initiative. Hungary is a well-known case. I think I don't have to explain to you. But it's not only Hungary, there are a few, but it's a very small group of countries that we know will either abstain or may vote against. But as Anton explained, the whole project is based on this 2/3 majority. And the core group countries, they make up 38 of the 46 member states. So they have clearly the 2/3 majority. And also the whole construction of the tribunal, that's important to understand, is based on the idea that, in fact, it would not be the Council of Europe. All member states would not finance and support the tribunal financially, politically, but this is why we chose also this construction, which may sound a bit complicated at the beginning, to have a bilateral agreement with Ukraine combined with what we call in the Council of Europe a enlarged partial agreement, which is a kind of international arrangement whereby a certain amount of member states, together also with non-members, and as Anton said, we count very much on countries like Canada, Japan, Australia to join, hopefully others from Guatemala, Costa Rica. So, but this is perfectly possible in the legal framework of the Council to have such a flexible instrument. So the Committee of Ministers would simply, by 2/3 majority, have to authorize the setting up of this structure called Management Committee, which is a bit like the assembly of the parties to the International Criminal Court. And then only those countries that actually support financially, politically, this process will join the enlarged partial agreement. They will set up the partial agreement, and then the statute also gives practically all the important functions, also relating, for example, to the election of judges and the prosecutor. They will be given not to the Committee of Ministers, but of the Council of Europe, but to these parties or members of the partial agreement. And I think this ensures that we have this flexibility in the Council, and there will be at the same time a solid foundation for the tribunal.
Well, thank you very much for your explanations, Anton and Jörg. But may I pick up, Jörg, on one of your last points about the funding? Can you please tell us more about the funding prospects for the tribunal and who you think are the potential donors will be? And by the way, what would be the estimated annual budget of the tribunal if you already have a feel for that?
Yeah, I think, of course, money is important. not only the legal texts. We have not yet the draft budget for the tribunal because there are still some factors which have to be clarified. In particular, also with the host country. You can imagine many of the costs relate to buildings, to security, detention facilities, and all these issues. They may be offered or given under very favorable terms, but they may also cost a lot if, for example, we have to pay for security on our own. It will already be, given the important security requirements, it may already cost a lot of money. But if, for example, since the tribunal will normally be hosted by the Netherlands, if the Dutch police or gendarmerie will ensure the security, all these millions will not be part of the budget. It would be part of what the host country offers. So it makes a huge difference. In any case, we anticipate also the tribunal will be set up. This is foreseen in the statute by stages. So in the beginning, it cannot be fully operational in a minute. The legal instruments are adopted. It will require a first phase, inception phase, and there have to be negotiations, host state agreement, the premises, all this. But on the money side, I think I can give a comparative figure maybe, which is also known, the Kosovo chambers, which is also a tribunal, which is not totally comparable, but it's also it's a relatively single, or it does not concern the whole world and a host of crimes, but only Kosovo and certain crimes. And here it's the same. It will be only the crime of aggression committed against Ukraine, and that will not be the whole world. So the Kosovo chambers, I think they have a budget of around 50 million. And this would be more or less the range we anticipate. But as I said, we have not yet detailed figures on this.
And Anton, do you know who already expressed willingness to fund the tribunal?
Thank you, Mykola. So what I want to add to Jörg's points, which of course I totally share, and we with the Council of Europe are really these partners in crime, and we are extremely grateful to Jörg, Constanze, Irene for their tremendous job. I mean, it's really incredible. So I would like to reiterate what Jörg mentioned, that these tribunals should be a rather compact thing. So it will not cost like hundreds of millions, because this is only one crime. So I think that it can even be less than KSC probably. And since we will also have the proceedings in absentia, I think this can also be rather cost effective, hopefully. I may not now probably as a diplomat talk about who already said that they will support the tribunal financially, but there are already some voices. So as of now, nothing official, nothing with official letters, or whatever, but colloquially, some of our major international partners already said that they are really very seriously considering supporting the tribunal in all the senses, including functioning, including financial things. So we hope that when all the necessary decisions are made within the Council of Europe processes, including the Committee of Ministers, we hope that with the financial issues, and I mean, even if it's, 40 or 50 millions, it's even not compared to 2 tanks, which can be transferred to Ukraine. So, of course, tanks are more important because military assistance is a crucial thing. But I think that in addition, this amount should not be a very big burden for our international partners and friends.
Colleagues, I have a related question. As of now, what are the expected and realistic timeframes for the establishment of the tribunal and for its actual start of operations? And related to that, will Council of Europe member states would have to ratify the agreement before the tribunal is operationalized? Or maybe not all Council of Europe member states, but the members of the membership committee. So I'd be grateful for the clarification about that as well.
Yeah, this is precisely the subject of discussions that are ongoing today in the Committee of Ministers. The documents are restricted for the time being, but the decisions, they will be public normally immediately after adoption. But I can tell you, precisely the Secretary General of the Council of Europe, Alain Berset, who is personally very committed to the process, he proposed or introduced the roadmap into the discussions. And of course, certain parameters we do not control because we do not know for now how long the process will be before the adoption of the first set of decisions, which will be first to authorize the Secretary General to sign the agreement with Ukraine, and the general decision that such a partial agreement or enlarged partial agreement that I mentioned will be set up, because you need for such an animal, you need two decisions. First, a decision to authorize in general the setting up, and there also Hungary must or can vote, but as I said, 2/3 majority is fine. And then you have a second decision, which will be only taken by those countries that actually join this partial agreement. And the first decisions, we hope very much, best case scenario, will be adopted before the summer break, beginning of July. And then we have an unknown factor that you refer to also. This is the factor to what extent or how long will the internal procedures take, how much time they will take in the different countries that want to join. Because, as I said, the second decision, which will be the adoption of the statute of this enlarged partial agreement, will be taken only by those states that actually join. But since it is not, strictly speaking, an international treaty, but simply a resolution by form, it will be a resolution of the Committee of Ministers, it will be immediately operational. So the countries, whatever national procedure they need, they must go through that before adopting the resolution, the second resolution, setting up the partial agreement. And what we hear from some countries, we heard that they may not even have to go before Parliament. But I think the vast majority will, because it is, after all, politically sensitive decision. It has financial implications, not unimportant financial implications. So most countries will probably, certainly have to go through such a process. And only once they have obtained the consent by Parliament, then they can notify the Committee of Ministers, we are ready now to join the resolution. And in the end, it's not a legal issue, this is a political discretion, how many countries we need to adopt this statute. Of course, being understood that other countries may join at any stage later. But to start with, you need a critical mass. In the Council of Europe, we have a general rule, you need at least 16. But given the importance also of this issue and legitimacy concerns, I think 16 will not be enough. I think the Committee of Ministers will only adopt the second resolution once they are. It's difficult to say. I don't know what Anton thinks, but I think must be more than 30 countries that also to distribute again the costs more evenly. Of course, as I said, other countries which may have delays in the internal procedures may not be able to adopt. on the very day this statute, but they may join later. As we had the same process with the Register for Damage, you may be familiar, which is also based in The Hague.
If I may just jump in also on this matter. So of course, I concur with everything what Jörg mentioned on the Council of Europe procedures. So we, on our side, we are trying to make everything possible for this issue to move as fast as possible within the Council of Europe. And our colleagues in Strasbourg know this. In particular, we hope that today, so actually our today's discussion is very timely, because today we are hoping to have a Committee of Ministers decision, which would have a good timing. We hope that all these internal procedures now in the Council of Europe will not take a long time, and hopefully quite soon Mr. Secretary General will be authorized by the Committee of Ministers to enter into bilateral agreement with Ukraine. So on our side, on the side of Ukraine, we do not need any authorizations, any full powers or powers. Anyone from our Troika, head of state, head of government, Minister of Foreign Affairs, can enter into agreement with the Council of Europe for the establishment of the special tribunal. So anytime, any day, when we are ready and when Strasbourg is ready. So of course, after the agreement, bilateral agreement on the establishment of the special tribunal between Ukraine and the Council of Europe will be signed. As far as I understand, for the Council of Europe, it will become automatically valid, automatically legitimate. For us, we will need ratification because on this matter, on such an important issue, under the law of Ukraine on international treaties, we will need ratification. But of course, we already started to work on the most fastest possible way, fast track, for us to move as fast as possible with the ratification in Verkhovna Rada, in Ukraine's parliament. And then, I mean, since the agreement will be signed by both parties, and Ukraine will ratify the agreement, so it will become valid for and legitimate for both parties. And the statute of the special tribunal will be annexed to the bilateral agreement. So I think personally, this is my personal view, it's not covered by any kind of powers or authorizations by anybody, but I think that bilateral agreement really can be signed this year and can be ratified this year. So I don't see any impediments or hurdles for that if hopefully the process in the Council of Europe moves in a proper way and within this fast track approach. And then what Jörg, of course, rightly mentions, the enlarged partial agreement issue comes into play, which we will need more time to do, yes, for the states to join large partial agreement, for the states to join the managing committee and to have the ability to participate in administrative and financial issues of the work of the tribunal. So I think that the agreement on the establishment of the tribunal really can be signed this year. But of course, the whole operation will need some more time. Again, our instruction here in Kyiv is to move as fast as possible. And this is what we also try to convene our, to make our message in Strasbourg, in particular today, during the Committee of Ministers meeting. So yeah, I think this is it. And what I want to reiterate, and maybe to finalize my comment now, is that we now talk within the legal scene, with legal community of Ukraine, yeah, and our international friends who joined today. I want to reiterate that the job of lawyers is done. So we found the solution. We found the package with which everybody can live with, which is important for the establishment of the tribunal. So our legal job of Constanze, Irene, Jörg, myself, and my colleagues, done. Now it's for the political issues and for political masters to take all the relevant decisions. But of course, we as lawyers are trying to make our input into the right decisions of political masters. So let's see how it works.
Well, thank you, Anton. I think that's That's a great segue to my next question. Well, first of all, thank you for the great job of all legal teams, both in Ukraine and in Strasbourg, on making this happen. But I think there will be more work for lawyers in the future, and that brings me to my question about the selection of future officials. Let's dream a bit about the future. Once the tribunal is established, and we realize it will take quite a few more months. Is there a mechanism for the selection of key officials of the tribunal, the judges, the prosecutor? Have there been any discussions or considerations? Who will be selecting and what will be the criteria, etc.? Can you shed a bit more light on this? And maybe Jörg can start with it, and then Anton will, I mean, whatever is more convenient for you.
Yes, thank you, Mikola, for this very practical question. It's very pertinent. In fact, the statute foresees the procedure for the election of the judges and the prosecutor. And as I said already in a previous intervention, it will not be the Committee of Ministers, but it will be the Management Committee, because it's natural that those states that actually support financially the tribunal should also be involved in the decision-making process. And then candidates, the process is detailed in this in the statute. I will not go into all the details. We hope very soon. I think one of the first decisions of the Committee of Ministers should also be to make finally these texts public, because I think it is really a concern of the legal community, not only in Ukraine, but of course in particular in Ukraine, to know what is actually in these texts. So I think that's very legitimate. And but since now these texts were only given at the ministerial session, and the Committee of Ministers has not yet taken a decision on that. But to come back to the question, so the judges and prosecutors, and they will be elected by the states in the management committee. The members, all participating states, can propose candidates. And then when it comes, I don't know whether, can I say this, Anton? I don't know about nationality.
Oh, please do.
Interesting. I mean, it is not actually. It was a very interesting solution. Was in the end found that there's no exclusion. It is a very, as I say, the detail you will see once the text become public. We have, in fact, my colleagues remind me, we have what is public is a frequently asked question document. I don't know whether you had an opportunity before this, before our recording, to see this. It's on the website of the Council of Europe, where we can provide the link. There you find at least sort of the main information in also for journalists, but also general public lawyers, interested lawyers, description of the procedures. But what is interesting for nationality, it's not excluded. There's no exclusion. So there can be also nationals of a country which is not member of this enlarged partial agreement. And there can be Ukrainian judges, there can even be Russian judges. So there's no exclusion criterion based on purely nationality. Of course, if a person is excluded by other reasons, they being not competent or not having the moral integrity for the job, this will be verified. And we have also an advisory panel of independent experts which will evaluate all the candidates before election, to make sure that only candidates that live up to the high level, being qualified for highest jobs in national judiciary, so that these
selection criteria are actually fulfilled by all candidates. When it comes to staff of the registry, there, since the tribunal will be created, of course, totally independent and autonomous, but still within the wider framework of the Council of Europe, normally the usual rules in the Council will apply. So there will be open competitions based on first selection by on interviews and also computer tests, the usual selection process for an international organization, which will be applied also for this tribunal. And of course, for this job in particular, but also background checks on to make sure that we have no spies in the tribunal, for example. We must ensure also this, that only persons that offer all the guarantees of independence and qualification can get the job. But Anton maybe want to complement also.
Yeah. Thank you very much, dear Jörg. In relation to Mykola's question, well, I would reiterate what I've said. The legal job by lawyers is done. And what you saw just now by Jörg, so he took the statutory drafts of documents and took the provisions from there. So of course, the draft of statutory documents include the provisions for the positions of judges, of prosecutor, of deputy prosecutor, of the staff of the registry. So it's already there. So legally, it's already there. The only issue is to give the political impetus to these things. And yes, it's very important that we are not limited in relation to nationality, because I mean, who knows what will happen and who knows what Russia will look like the day after tomorrow. And there can be some reasonable Russian judge who will act in favor of the tribunal. But nevertheless, whatever. So this is all set in the documents, and it's ready to be operational when and if the member states of the Council of Europe so desire and so decide. Another issue which I think is also important for us here to understand, that we haven't yet talked about the personalities. I mean, we need to eat this elephant by portions. And this is not about the job positions for somebody. So we are doing this tribunal not because of somebody wants to have an international job. We are doing this tribunal because this is the right thing for the history, for international law, and in my case, for my country. So this is the main thing. We will think about personalities afterwards when we have the necessary relevant international decisions.
May I ask a follow-up question with regard to the personnel? Is there understanding or maybe some criteria about which position should be held by Ukrainians, or a percentage of Ukrainians on the list of judges? Is there any rule or any discussions about the Ukrainians on at the tribunal?
I may start, if Jörg agrees. We didn't have any kind of discussion on that within the core group, because, I mean, for core group, the job was to have the drafts ready, and they are ready. So in the 3 draft documents necessary for the establishment of the tribunal, there are nothing in relation to nationalities. You may hear now Mikhailivsky Monastery just outside my window. So my personal opinion is that either all the judges or the absolute majority of judges should be international judges. Because I believe that it's a matter of legitimacy. We need to show the international character and the international dimension of this tribunal. And we need to show that it's not Ukrainians who judge Russians for their aggression against Ukraine, because Ukraine is a victim state. So there can be issues with legitimacy of such decisions. And I believe also that the prosecutor should not be a citizen of Ukraine. But again, these are my personal ideas. And I would reiterate that for Ukraine's government team, this job is not about vacancies. This job about making the right thing for our nation. And I don't want, and I will do everything possible when the tribunal is set and established, that we do not have the bad things of fighting for jobs or career opportunities. This should be ideal tribunal, and we will do everything possible to secure this.
Thank you very much, colleagues. And I would like to also ask a question about investigation. Do you envisage that the tribunal will have its own investigative unit, or it will rely on the investigation previously conducted by someone else? And connected to that, what will be the fate of the ICPA, the International Center for the Prosecution of the Crime of Aggression, in the context of the establishment of the tribunal?
Yeah, thank you for this important question. And in fact, there, both what you ask, both will happen. On the one hand, the tribunal will use the evidence already gathered by under the aegis of ICPA by those states that participate in this framework. I think it's 7 or 8 states. And in fact, there is already, since this creature was created under the umbrella of Eurojust, there is already very close contacts and close collaboration with our EU colleagues who will prepare an agreement which will allow to transfer the data from ICPA, from the participating states, to the tribunal. Of course, such an agreement can only be concluded once the tribunal comes into existence. But I heard our colleagues in Brussels, they already they are already on it to have a draft ready. And I was also recently at a meeting in The Hague where all the, even the president of Eurojust, they assure us of this collaboration. And what also seems to be a very important news is that even the US, you may know the US was a very active member of the core group. In fact, they provided very good and substantial input into the drafting. But then, of course, following the election of Mr. Trump, and they could not participate any longer in the final conclusion of the work, but they were also participating in ICPA, where they also withdrew. But what we hear is that they do not object, that even evidence that the US had submitted in the ICPA database can be transmitted to the future tribunal, which I think is very important. And there is a lot of evidence. There are terabytes, in particular, of satellite images that already exist and that are available. And so, but of course, once the tribunal is established and the prosecutor's office, also the prosecutor of the tribunal will carry out his or her own investigations. And it's also important to stress that they will be fully independent. I mean, Ukraine will refer cases, evidence, information to the tribunal, and but the tribunal the prosecutor will be independent in the evaluation of this evidence and in the preparation of the indictments, and can, of course, then carry out investigations in Ukraine, but also elsewhere. This will, of course, then also depend on another aspect that is very important for the tribunal, maybe less visible. It's the cooperation agreements, which are not part of the 3 documents now currently also before the Committee of Ministers. But there's also already, thanks to our Dutch colleagues who helped a lot, and we prepared There is already kind of templates for cooperation agreements to make sure that the states that will provide evidence or can cooperate, transmit evidence to the tribunal and have a legal basis also, for example, to enforce sentences that will be issued by the tribunal. This aspect of cooperation is key because the tribunal, being there alone in The Hague, cannot do much. It needs to have a strong, solid basis through cooperation agreements. In fact, yeah, sorry.
Yeah, Anton, do you have anything to add to this? Well, I realize that we have about 10 minutes left, so we have a few, two more questions actually that we would like to raise with you, if you don't mind. So, turning to the issue of the evidence and the materials that are provided, will be provided to the future tribunal. Do the tribunal's statutory documents specify clear criteria under which the Prosecutor General of Ukraine will transfer cases to the tribunal? Or there won't be any such limitations and it will be up to the Prosecutor General to decide which cases to transfer to the review of the tribunal?
Yeah, thank you so much for this question. So, first of all, we really believe that this scheme, this formula of referring by the Prosecutor General of Ukraine to the tribunal is really a working one, in particular when we also think on top of our head about the decision of the Constitutional Court of Ukraine of 2001 in relation to International Criminal Court, so that it cannot be the sole competence of some international body to start something on Ukraine, because then the court of Ukraine may decide that it's not in conformity with the Constitution of Ukraine. So this securing element of transferring or referring by the Prosecutor General of Ukraine, we believe that it suffices and satisfies this moment. And I would like also to reiterate and mention that this is not only about referring or transferring the case. This is about referring actually anything in relation to the case, because when we transfer a case, so it can be transferred only in relation to the persons who are accused there in the case, or who are suspects. So it would have limited the tribunal in relation to jurisdiction ratione personae. But here in the draft statutory documents, in particular draft statute, we have the provision that Prosecutor General of Ukraine can transfer or refer, we have the word refer, anything, case, elements of case, materials, elements, whatever. And on the basis of these, the prosecutor of the special tribunal will build the case. So with such a discretion for the Prosecutor General of Ukraine, we see that we give the discretion for the prosecutor of the special tribunal not to be limited with the findings of the Prosecutor General of Ukraine, but to go forward, to go deeper, to go wider in relation to persons, if he or she, the prosecutor of the special tribunal, will decide so.
Thank you. This is clear. Jörg, do you have anything to add to this, or should we move on to our last question?
No, please move on. Yeah, this was.
Thank you, colleagues. Actually, we've mentioned, Mr. Koronevich mentioned the Constitutional Court, and we were wondering whether there were consultations with the Constitutional Court to make sure that the format suggested by the core group is acceptable in view of the Ukrainian constitution. And do you have any other possibilities that someone might officially refer the question about constitutionality of the tribunal to the Constitutional Court in Ukraine and impede the process of its establishment in this way?
Well, This is, I think, not a question for which we can have 5 minutes, which we have now. On our side, I would mention several things. First of all, we believe here in our Ministry of Foreign Affairs of Ukraine that the matter of the establishment of the special tribunal is a matter of national interest of Ukraine. This is one of the most important reactions to Russian aggression. Only the military answer can be more important than this, we believe. So we hope and believe that no one in Ukraine's society would do anything to harm the process or impeding the process of establishment of the special tribunal. If somebody does this, the reasonable questions would arise: for what reason and for whom such actions can be done? Who is the party who is interested in such a behavior, in such a conduct? So I think we need to start the answer to this question from this. Either anybody in Ukraine's legal community would question this, and if yes, for which reason? I hope that the answers would be negative, because I would not accept any other questions personally. We, of course, consulted with constitutional lawyers of Ukraine. You may not be sure, on reaction of, we have thousands of courts in Ukraine, district courts, who can adopt any kind of decisions, you know what I mean. But I really hope that everybody understands what legal profession is, what your legal job is, and what your obligation is while you perform this job. So we try to do everything possible to not have any issues in the draft documents for the establishment of the special tribunal, which can raise any kind of issues of constitutionality. But personally, myself, I may question also the decision of the Constitutional Court of 2001. And I know that many other lawyers also can, and they do this. So you cannot be sure 1000%, but I'm sure and I'm confident that our Ukraine's legal team, and we had members of not only our Ministry of Foreign Affairs who deal with international law. While working on the tribunal, we had members of Ministry of Justice, Office of the President. We consulted with many professors and professionals on internal Ukrainian law, in particular constitutional law. So we really hope that these questions will not emerge, and that this process would be very professional, effective, and speedy and fast on Ukraine's side.
Thank you, colleagues.
Maybe just no, not on Ukraine. I would not venture into Ukrainian constitutional law, but just to reiterate also, I think speaking in the name of the whole team here, it was really, I think, a unique experience to work with Anton and his team on such an important issue. I think it's really historic. And the lawyer's job, as Anton said, has been done. Now it's really the political masters have to follow up. But as I said, what I hear today in our committee of ministers is a very strong message of support. And the ministerial had said very clearly it's a high political priority for the Council of Europe to follow up this request of Ukraine, its member state, victim of such an egregious aggression. And it brings really the council also back to its roots, founded in 1949, precisely after the Second World War, under the slogan "Never Again." And I think it couldn't be a better project for the 75 years of our organization and the European Convention on Human Rights than to do this together with Ukraine. Thank you.
Absolutely. Well, let me summarize what I heard. I've been taking notes during this podcast. So, first of all, again, Jörg and your team, thank you so much for joining us and for sharing your views. And of course, first of all, for your enormous work on this very important matter for all of Ukraine. Anton, thank you so much for spearheading this effort on the Ukrainian side and for sharing your views on this. It seems like the special tribunal is likely to be voted in and the agreement ratified by the end of the year. We keep our fingers crossed for that. We realize that more actions would need to be done at the level of the member states to ratify agreements on the enlarged partial agreements, but we are moving quite quickly in that direction. The special tribunal requires 2/3 of the votes of all member states of the Council of Europe, and that is a very likely majority that will be attained. We keep our fingers crossed. The cost will be around 50 million euros or even less, as Anton suggested. The selection of candidates hasn't begun yet, but there will be advisory panel of experts, who will vet the candidates. There will be some testing, there will be some integrity checks, etc. And then there will be, of course, election of the judges and the prosecutor by the management committee of those states that support the establishment and funding of the tribunal. And of course, there will be evidence coordination, and there will be a lot of evidence provided by Ukraine and by the European Union and other states. So hopefully the tribunal will have a lot of information to digest. The Prosecutor General of Ukraine will have very broad discretion on purpose to submit not only cases, but also different evidence and elements of evidence. And ultimately, we all believe that this is in the best national interest of Ukraine to have this tribunal established, to have international judges and prosecutors to act independently, to show that it's not only retribution by Ukraine, but it's definitely done in the interest actually of the civilization, to do it properly in the interest of international order and international law. And of course, we believe, and the Ministry of Foreign Affairs believes, that this is done in accordance with Ukrainian constitution, and hopefully we won't have a question of constitutionality in Ukraine. Anyways, we are very excited as the Ukrainian Bar Association that this process is now moving in the right direction and so fast, and many important milestones have already been achieved and completed. We have been supporting since the beginning of the full-scale invasion and advocating for the accountability of Russia for the crime of aggression. We believe that this is a very solid compromise and actually a very good solution to prosecute it under this special tribunal arranged within the framework of the Council of Europe. And we, again, thank very much the whole Council of Europe and dear colleagues who joined us today for your efforts. And we hope that this tribunal will be established, will be operational, and that justice will be served. So on behalf of the Ukrainian Bar Association, I really thank you. And Ina, I'm sure you have a few final words on your part as well.
I concur with everything you said. I also would like to thank Anton and Jörg for your time and participation today. And before today's event, we organized a series of discussions dedicated to the tribunal, and we appreciate the possibility for the legal community to engage in the discussion and to share our thoughts on the tribunal with the decision makers. I would like to invite our the viewers of this webinar to follow the activities of the Ukrainian Bar Association and its Human Rights Institute, because we plan a lot of interesting events in the future. Thank you once again, and have a wonderful afternoon, colleagues.
Thank you, and have a great day. Bye-bye.
We are done with the broadcast.
All right, we are offline.